Welcome back, everybody. Again, my name is Bria Golder, attorney at law, and today we are going to talk about knowing your rights. Oftentimes we get into situations and a lot of people do not know their rights. You know, they talk and say things that they don't have to. They consent to things that they don't have to, simply because they don't know their rights. You don't know the rights that are offered to you in the United States Constitution. So today we're going to talk about 3 important rights that everybody should know that they have available to them. And the first one is never consent to a search. Never, ever, ever consent to a search. This right is given to you in the 4th Amendment. Of course, with any right, there are always limitations and defenses. So a 4th Amendment search and seizure is not applicable for every search that you may go through. There are exceptions. One of the exceptions is called a Terry stop and frisk. So a Terry stop is if you're walking down the sidewalk, or if the police just got a tip off that a robbery just occurred and you fit the bill of the description that they received. So let's say that a robbery happened and the person was described as a African-American, light-skinned woman with a long ponytail, dressed in a peach jacket. And I'm walking down the street, I fit that description, but I didn't do it. They may stop me and say that they got a description, and that may be probable cause and a reasonable arrest. Or they could stop me and frisk me, which means just pat me down for the stolen property in which they received the tip-off that was transpiring. So all of those are exceptions to the 4th Amendment search and seizure right. But let's focus on that right in particular. Overall, never, ever, ever consent to a search. If an officer asks you, is it okay if I search your vehicle? Is it okay if I search your pockets? Is it okay if I search the trunk of your car? Is it okay if I take a look inside of your apartment? No, it is not okay. It is never okay. It's just not okay. If they have any suspicion, they can go to the office and get a warrant to search your property or your person meaning your body. But if they are asking you for consent, you should never give it to them. Never give them consent to search. They should find reason by reasonable suspicion or probable cause to be able to conduct a search. But you should never consent to a search. That is your 4th Amendment right. You do not have to consent to a search. If an officer asks you to search, no, you may not. And you don't have to be rude about it. Still be careful, but you do not have to consent to a search. Here's why. If the officer searches your car anyway, or searches your home anyway, but you did not consent, that's a violation of your 4th Amendment search and seizure right. So your attorney, let's say you're charged with a crime, your attorney can come in and argue that. They can fight against that search, or they can get that information or evidence suppressed, which means that the court won't be able to use it against you if the search was not valid. The search can be invalidated if you did not give consent. But if you give consent to a search, that means that the officer did not need probable cause. They did not need reasonable suspicion. They did not need to meet any of the other exceptions because you gave them consent. If you say yes, anything goes. So never consent to a search. If they do it anyway, still don't consent. Say in your mind, okay, that's fine that you're searching, but I know this isn't going to be useful in court, and I'll have my attorney fight my battle. But never openly, verbally consent to a search. If they are asking you, no, it is not okay. You do not have to consent to that search. Another common exception is the vehicle exception. So if you're in your car and an officer smells marijuana, or if they have the dog out, they don't need a warrant to bring the dog around to sniff your car for drugs. If the dog detects something, or if the officer smells something, that is reasonable suspicion. They don't need a warrant if they have reasonable suspicion. They are able to search your car for those reasons. That is the automobile exception. So be careful who you ride with, because let's say they search the car and they find marijuana, or maybe they don't find marijuana, but they find a gun. Their search would likely fall under the automobile exception. And if the owner of the gun does not take ownership of that piece of property, you could potentially be found liable for that gun. So be careful who you ride with. Be careful of what's in the vehicle, because all passengers in the vehicle may be potentially held liable as well if no particular person takes ownership of the property that violates the law. And that qualifies for a home search as well. Whether the search is lawful or unlawful, the things that they find may or may not still come into the courtroom. And so you want to be careful about what's going on in that home when you are present. Another exception, as I already spoke about, is the stop and frisk. If they've gotten a tip-off of something transpiring and you fit that description, or if they know that a particular area is common for unlawful crimes, they may stop you and frisk you, but they can only frisk you for weapons and illegal paraphernalia, so drugs, things of that nature. If they feel something and they think it's a weapon, or they think it's drugs or paraphernalia, they can take that out of your pocket, or they can take that out of your sock, or wherever it's located. And if it is, then it's useful for them in their case. You still may be charged or in trouble for that, depending on what the item is and what the circumstances are. Another exception is the search incident to arrest. So if you're being arrested, the officer is able to conduct a search. However, with this particular search, they can only go in arm's reach of the person that is being arrested, because anything else they have time to go get a warrant for. So they can go in arm's reach of the person that's being arrested, because that's reachable for that person to grab before they get arrested. So they're able to search the area to gather evidence or paraphernalia of that area as that person is being arrested. Plain sight is another exception for searches. So when an officer has a search warrant, let's say that they've gone through the process, they've gotten a search warrant, the officer is limited to only searching the area that is listed in the search warrant, and they can only search for the objects that they are trying to retrieve from the search. So if they believe that you are a drug dealer and you have cocaine in your home, they can only go to the home and search for cocaine. They can't look for anything else, and they can't look in areas where cocaine wouldn't be. So let's use another example. If there's been a robbery in the area and they have a search warrant to search your house for stolen computers, they cannot look in the drawer for a stolen computer if the drawer is not big enough to hold that computer. They're only able to look in places where the computers could possibly be. So hopefully that makes sense. The warrants have to be specified to limit the officers to that search. They can't just go in looking for any and everything. They have to go in looking for exactly what it is that the purported criminal is in trouble for, and then they have to hopefully come out with only those items. However, there is an exception: the plain sight doctrine. So plain sight means that if they come into your house and they're searching for computers, but they see marijuana on the table, that they can bring that marijuana into evidence as well, because it was just laying out in plain sight. Same for your car. If they pull you over for a routine traffic stop, but they see an open bottle of alcohol in the car and they smell alcohol on your breath, then that gives them reasonable suspicion and also plain sight to be able to conduct a breathalyzer and bring you in for possible driving under the influence. So all of these exceptions matter, and you want to keep those in mind, because it's not that the police can't search your property. It's just that typically they have to obtain a warrant prior to the search, unless other circumstances exist that fall within one of the exceptions. The last exception I'm going to discuss is exigent circumstances. So if the police don't have time to get a warrant before the criminal conduct has concluded, then the police are able to come in and go ahead and conduct that search so that they don't have to worry about the possibility of the conduct concluding or the materials being moved around out of this space before they have the chance to catch the alleged criminal in the act. So those are extended circumstances. And then one rule that we're not very favorable of is the knock and announce rule. So police are supposed to knock and announce when they come to your house to do a search, when they come to that place of business to do a search. Wherever they are, they're supposed to knock and announce their presence. Open up, it's the police, whatever they say. They are supposed to knock and announce. However, if they do not knock and announce, that still does not mean that they will be unable to use the evidence that they gain from that search. So although this conduct may not reflect well on the police department, even if they don't knock and announce, that does not mean that the evidence will be thrown out. So essentially, they're supposed to knock and announce, but they don't have to. Always keep that in mind, and always make sure that you are conducive with the police and that you participate with them, but remember your rights. Do not consent if they ask for your permission, because they could then be conducting unlawful conduct that your attorney can fight on the back end. Another defense for you. Defenses work for the criminal defendant. Defenses help your case. So the first defense we have is lack of probable cause, lack of a search warrant. You conducted this search without a warrant. It didn't meet any of the exceptions. I did not give you consent, so the search is invalid. Another exception that we have is fruit of the poisonous tree. So fruit of the poisonous tree is when the search is invalidated for whatever reason. I didn't give you consent. You didn't have a warrant. None of the exceptions existed. There were no exigent circumstances. There wasn't anything in plain sight, et cetera, et cetera, et cetera. So you conducted this search and you got evidence that is fruit of the poisonous tree, which means you received evidence that came from your unlawful search of my property. This is good. So if they have fruit of the poisonous tree, a lot of times that evidence will not be admissible into the court hearing. They may still be able to use that evidence in a grand jury trial or possibly in a sentencing hearing, but they will not be able to use that in your actual jury trial because that evidence was not gathered lawfully. Number 2, I am not answering any questions. I'd like to speak with my attorney. So if you feel like you are detained, which means that you are either in handcuffs or you feel like you're in a situation where you cannot leave, you cannot get away, you are not answering any questions, you'd like to speak with your attorney. Of course, in a routine traffic stop, if an officer pulls you over, you want to show them your license, ID and registration, please. Go ahead and offer those documents. If they ask for your insurance, go ahead and offer those documents. Routine questions, go ahead and answer those. But if it feels like you are being interrogated or asked about some other crime, you do not answer any questions. I am not answering any questions. I'd like to speak with my attorney. That is your Fifth Amendment Miranda right. Sometimes officers do not properly Mirandize people, which means that they tell you you have the right to an attorney, you have the right to remain silent. Anything you say can and will be used against you. If you don't hear those Miranda rights, still know that you do not have to talk. You have the right to remain silent in any police interrogation. You want to participate with the police, but that has limits. Always know your rights and remember your right to remain silent and your right to speak with counsel, especially if you've been detained. And especially if they've given you those Miranda rights. If the officer says that, make sure you invoke that Miranda immediately. You say, okay, I'm invoking my Miranda right. I'd like to speak with an attorney. And after that, don't say anything else. That is a very important right. So recap, never consent to a search, ever. Never consent. They may do it anyway, but never ever consent to a search. And number 2, never ever ever talk without an attorney. I do not want to answer your questions. I like to speak with an attorney. Okay, number 3, if you feel like you are being detained, make sure that you say to the officer, I do not agree to stay here. Am I being detained or am I free to go? That lets the officer know that you feel like you are being detained, that you feel like you're not free to go, and that they need to let you know if you are or you are not, so that you can leave or so that they can move on with the process if they are going to arrest you or whatever the case may be. You must say, I do not want to stay here. Am I being detained or am I free to go? Make sure they know that you don't agree with being there. Again, you want to cooperate with law enforcement, but not to the point where it infringes upon your constitutional rights. Because of course, if you're being detained, now we have the right to counsel. We don't want to speak. We don't want to answer any questions. We want to know what's going on. Why are we being detained? There are quite a few things that are invoked at that point. So make sure if ever you feel like an officer is holding you longer than you need to be held, you let them know, I do not agree to stay any longer. Are you detaining me or am I free to go? Make sure you say that. Never voluntarily stay around with the police. And again, I say voluntarily. Of course, again, you want to cooperate, but never just voluntarily stay around with the police. You want to make sure they are being efficient in their process and that you are able to handle what you need to handle and move on. You cooperate with them for what they need, and then you move on. You remove yourself from that situation, because anything else means that you need an attorney if you're being detained. But you never want to just voluntarily stick around if the police are not making you stay there. One thing I want to discuss that a lot of people misunderstand is self-defense. So if somebody hits you with their fist at a party, you can't pick up a glass bottle and smash it across their head. That's not self-defense. Another thing, if somebody hits you at a party and then they walk away, you can't chase after them and hit them back. That's not self-defense. Self-defense, of course, has to be started by the opposing party, by the opposite person, but it still has to be an imminent threat of harm. So you can fight back if that person is fighting you in that moment. But when they walk away, they're no longer a threat. And so you can't invoke self-defense in that case. Also, they can't punch you in the face and then you pull a gun and shoot them. You have to fight with equal force. If you're at home and a burglar comes into your house or something of that nature, and you're unsure of what this person may be armed with, and you feel imminent threat of harm or danger, which means you are afraid for your life. If you see that person coming towards you, you can shoot, you can do whatever to protect your property, protect your space, but there has to be imminent threat of harm or danger. Same thing if you're out in public. If you see somebody with a gun and you feel frightened by them, you can fight back in that same manner, but you have to feel imminent threat of harm or danger. It cannot be a future threat. If I tell you, I'm coming to your house at 6:00 p.m. tonight and I'm gonna fight you, but it's 12 o'clock in the afternoon, that's not imminent threat of harm or danger. That's a future threat. So that would not fall under self-defense. Make sure you understand self-defense, because a lot of people try to claim self-defense when it's not a viable defense for the crime. So make sure you understand what self-defense actually means and when you are able to use self-defense as a defense for your behavior. So in conclusion, let's recap. And of course, there are tons of other rights given to you in the Constitution, but these are the main three when dealing with criminal proceedings. Make sure you know these three rights. If nothing else, you are 10 steps ahead from a lot of people at your age if you know these rights. Number one, never, ever, ever, ever consent to a search. If the officer asks you, may I search your vehicle? May I search your pockets? May I look for this? No, you may not. No, they still may do it, but let your attorney fight it on the back end. Never consent to a search. Number two, value and know and always invoke your right to remain silent. No, I do not want to answer any more questions. I'd like to have an attorney. Anytime you feel like you are being detained or questioned about things that are not pertaining to the matter at hand, which really would be a simple matter like a traffic violation. Anything more serious than that, you don't have to answer questions for the police. As I've said before, you want to cooperate with law enforcement. You want to be respectful to law enforcement always. They have the power. You want to acknowledge that power and know that they have the power, but you do not want to violate or give them reason to violate your constitutional rights. Invoke your right to remain silent. Do not answer questions. And if it seems serious, ask for an attorney. You do not have to talk. Remember that always. Consult with an attorney and let them handle the situation. And number three, always ask the officer. You say, I do not agree to stay here any longer. Am I being detained or am I free to go? Let them know that you acknowledge the situation that you are in, that you have cooperated with them up until this point, that you feel that it is unlawful for you to continue sitting there wherever you are, and that you are ready to leave, and that they need to either arrest you and formally detain you so that you can invoke your rights, or they need to let you go. Never voluntarily sit around with the police. Handle the situation and remove yourself from the situation so that you can hire an attorney if it's necessary, or so that you can get whatever other business you need to get handled outside of that situation. You want to remove yourself from that bad situation as soon as possible. Hopefully this helps. If nothing else, remember those three rights. Thank you so much.